How in the world do you choose a jury for a former president? For all of Donald Trump's usually incorrect bluster about the legal process, he is correct that New York, Manhattan, by the numbers is pretty liberal, and Trump is entitled to a jury of his peers. But what does that mean in this context? How do you pick a fair jury? What does that even mean? Well, our resident prosecutor, Spencer the Scowl Owl, explains the jury selection process for the felony criminal prosecution of the former president.
The trial in the criminal case, People of the State of New York versus Donald John Trump, has begun.
Oh my God! Okay, it's happening. Everybody stay calm.
What's the procedure, everyone? What's the procedure?
Stay calm!
If you haven't been following the build-up to this case, perhaps because you live under a rock, or alternatively, because you have a full and reasonably happy life that doesn't revolve around national political drama over which you have little to no control.
Huh? What now?
Here's the summary of the case that Justice Juan Merchan actually read to prospective jurors. The defendant, Donald Trump, is charged with 34 counts of falsifying business records in the first degree. The allegations are, in substance, that Donald Trump falsified business records to conceal an agreement with others to unlawfully influence the 2016 presidential election. Specifically, it is alleged that Donald Trump made or caused false business records to hide the true nature of payments made to Michael Cohen by characterizing them as payment for legal services rendered pursuant to a retainer agreement. The people allege that, in fact, the payments were intended to reimburse Michael Cohen for money that he paid to Stephanie Clifford, also known as Stormy Daniels, in the weeks before the presidential election to prevent her from publicly revealing details about a past sexual encounter with Donald Trump. Donald Trump has pleaded not guilty and denies the allegations. Long story short, this is the porn star hush money case. It's the first criminal trial Donald Trump is facing. Legally, it's probably the least consequential. If Trump is convicted of all 34 counts, he almost certainly wouldn't face prison time. Yet it could be the only criminal trial Trump faces before the election. So the political impact of Donald Trump, felon, could be huge. First things first though, a jury of 12 ordinary people needs to be impaneled to decide whether Donald Trump is guilty. Jury selection. Lawyers call it voir dire, or if you're a deviant or a good old boy, voir dire. Justice Merchan has planned for up to 2 weeks to select a jury. In ordinary cases, picking a jury usually takes significantly less time. But this obviously isn't an ordinary case. Voir dire is really designed to do two things. First, ensure that a potential juror is qualified to be a juror under the law. And second, ensure that a potential juror can be fair and render an impartial verdict based on the evidence presented at the trial. Judges have fairly broad discretion in how voir dire is conducted in their courtroom. They have to follow the law, of course, but there's substantial room for each judge to do things differently. Voir dire is one of many circumstances where a good lawyer knows the law and a great lawyer knows the judge. In the federal system, most judges question the potential jurors themselves, even though the federal rules of criminal procedure allow for attorney questioning at the judge's discretion. In state courts, it is far more common for the attorneys to ask most, if not all, of the questions. Who are the potential jurors in this case? Where do they come from? In New York State, potential jurors are pulled principally from lists of registered voters. That's supplemented by DMV records, income tax records, you name it. Apparently, New York also allows you to volunteer for jury duty, which is, well, it's one way to pass the time, I guess. There are 4 qualifications to serve in a jury in New York State. A juror must first be a United States citizen and resident of the county to which the juror is summoned to serve. 2, be at least 18 years old. 3, not have been convicted of a felony. And 4, be able to understand and communicate in English. This trial is happening within the jurisdiction of New York County, also known as Manhattan. New York County has a population of about 1.6 million people, with 1.1 million registered voters. Of those, 70% are registered Democrats. Now, you might reasonably conclude that the remaining 30% are registered Republicans. But no, less than 8% of Manhattan voters are registered Republicans. Some people register with smaller third parties, while 20% of registered voters just left the party section blank on their voter registration form. It gets even worse when you look at past election results. In 2020, Joe Biden got 86.4% of New York County's vote to Trump's 12.2%. In 2016, Trump got just 9.7% against Hillary Clinton. Sounds like Donald Trump's going to have a hard time finding sympathetic jurors. But picking a jury in a Trump case is possible in Manhattan. 2 juries have already been impaneled in cases involving Donald Trump, the E. Jean Carroll defamation trial in federal court, and the Trump Organization criminal tax fraud trial before the very same Justice Merchan. On the other hand, neither case went really well for Donald Trump, so it kind of makes sense that his attorneys tried hard to move his trial away from New York City. 200 potential jurors got summons to appear on Monday, April 15th, for the first day of Donald Trump's criminal trial. It's quite possible that we will never know who these jurors are. Justice Merchan granted limited anonymity to the jury pool. The attorneys have the names and addresses of the prospective jurors, but that information cannot be copied or shared. The attorneys can use that information to do research, look at social media accounts, etc., but none of that information can go to the public. The morning of April 15th was largely spent with the attorneys arguing about some last-minute issues, and Donald Trump apparently falling asleep at counsel table.
I reported earlier that he had appeared to fall asleep. Now, we had seen him, and I want to be clear that I've seen lots of people fall asleep in courtrooms.
You could say he's anti-woke. The first pool of 96 prospective jurors were called into the courtroom Monday afternoon. Justice Merchan began by talking to them for about 30 minutes. He introduced the defendant and the attorneys, he identified the charges, and provided a summary of the allegations. He explained the process of jury selection, some basic principles of criminal law, and an estimate about what kind of schedule this trial would be on. He listed the names of the witnesses and people who would be mentioned during the trial, including people like Ivanka Trump and Rudy Giuliani. Justice Merchan then asked the single most important question for jury selection. If, based solely upon what you've heard to this point, you do not believe that you can be fair and impartial, or you are unable to serve for any other reason, please let me know now by raising your hand. Over 50 of the 96 prospective jurors in that first pool raised their hands and were immediately excused from service. This was unusual, but fully in line with the jury selection process Justice Merchan put in place before trial. Normally, if a juror were to raise her hand to that question, there would be further questioning. Why can't you be fair and impartial? Or why can't you be available for the whole trial?
I don't really think it's fair for me to be in a jury because I can read thoughts.
Dismissed.
When Justice Merchan oversaw the Trump Organization tax fraud trial, he would take the juror into an adjoining room with all the attorneys, a court reporter, a clerk, the defendant, etc., to ask those questions. It became such a time suck and logistical nightmare that eventually everyone agreed to just excuse the jurors who raised their hands. Having learned his lesson in that Trump Organization trial, Justice Merchan decided to start this trial just excusing the jurors without further questioning. The next step was for Justice Merchan to ask each remaining prospective juror a series of 42 questions from a questionnaire he prepared with input from the attorneys. These questions range from what neighborhood the juror lives in, educational and occupational background, hobbies, and what news sources the juror uses. There are questions specifically about Donald Trump too, from whether the juror has been to a Trump rally to whether the juror follows an anti-Trump group on social media. Each juror is also asked whether they support or belong to QAnon, Proud Boys, Oath Keepers, 3%ers, Boogaloo Boys, or Antifa. Noticeably absent from the questionnaire are questions about who a juror voted for or intends to vote for, campaign contributions, or specific political party registration. This is not an accident. The question of which political party a juror belongs to or who that juror voted for in the last election will virtually never, by itself, be a basis for a for-cause challenge, even under the unique circumstances of this case. To understand, all you really need is an example. Frank registered as a Democrat 30 years ago, but doesn't particularly care for the Democratic Party or politics at all. He lost his fantasy football league, and his Sacco punishment was to vote for Biden. In this example, Frank's party affiliation and voting behavior have nothing to do with any kind of personal feeling or bias toward or against Donald Trump. But come on, you might say, that's a wildly unlikely example. One, is it? Is it really? I mean, not everyone is laser focused on politics, like your uncle on Facebook who isn't invited to family dinners anymore. Two, the legal standard is not whether someone has a bias. Everyone has biases and personal opinions that they take into the courtroom with them. The issue is whether that person is reasonably capable of setting aside that bias and rendering a decision based on the facts and the law alone. Partisan affiliation and voter behavior don't get to that point. You see, after all the jurors go through the questionnaire, the court allows for follow-on questions from the attorneys. Just like the questionnaire, Justice Merchan won't let the attorneys ask specifically about liking Donald Trump or what political party a juror belongs to. As he said, voir dire is not an overly intrusive inquiry into the private affairs of prospective jurors for the purpose of obtaining personality profiles. The purpose of jury selection is not to determine whether a prospective juror likes or does not like one of the parties. Justice Merchan's point is that the attorney's questions can only be directed to the fundamental question of whether a prospective juror can be fair and impartial.
Hey Spencer, sorry to interrupt, but if you're choosing a jury for your hush money payments to a porn star, you'll probably want a good lawyer. But if you want a great lawyer, my law firm, the Eagle team, can help. If you've gotten in a car crash, suffered a data breach, especially if you got a data breach letter saying that your information might have been leaked, or are dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. It's so important to talk to a lawyer right away so you can get the best representation and find out what your options are. So just click on the link in the description or call the number that's on screen right now for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. So click on the link below.
Why is this so important? Because after the attorneys ask questions, they can challenge jurors in two separate ways. The first kind of challenge is called a for-cause challenge. When an attorney issues a for-cause challenge to a juror, the attorney is saying that there's a substantial risk that the juror cannot render an impartial verdict based on the evidence presented at trial. The judge then has to make a decision: grant the for-cause challenge and dismiss the juror, or deny the challenge and keep the juror on the panel. The attorneys get an unlimited number of for-cause challenges. The second kind of challenge is called a peremptory challenge. Under New York law, the number of peremptory challenges depends on the crime charged. Since Trump is charged with Class E felonies, each side gets 10 peremptory challenges. Unlike a for-cause challenge, where there's a burden to show that a juror is impartial, a peremptory challenge can be used for any reason at all. You can use a peremptory challenge because you don't like a juror's haircut. Don't like a juror's vibes? Peremptory strike.
Look at these people.
If you're the defense attorney for a player on the New York Yankees and a juror shows up in a Mets hat, use that peremptory challenge. There is one big carve-out though. You can't use a peremptory challenge on the basis of race. In 1986, the United States Supreme Court decided Batson v. Kentucky and held that it violated the Constitution's Equal Protection Clause for a prosecutor to challenge black jurors on the assumption that black jurors would be unable to impartially consider the state's case against a black defendant. If a defense attorney thinks a prosecutor used a peremptory challenge on the basis of race, that defense attorney issues what's called a Batson challenge. A Batson challenge has 3 steps. 1. Determine whether the moving party has made a prima facie showing that the other party has exercised a peremptory strike on the basis of race. 2. If so, decide whether the party exercising the challenge strike has satisfied the burden of offering a race-neutral explanation for the strike. And 3, if so, make a determination whether the challenging party has carried his burden of proving purposeful discrimination. Now, there's a lot of criticism of Batson and its progeny. A lot of defense attorneys think that it just doesn't have any teeth and it's way too high of a burden. But Batson doesn't just apply to the state. 6 years after Batson was decided, the US Supreme Court held that Batson also applies to criminal defendants, a so-called reverse Batson challenge. Defense attorneys can't use peremptory challenges on the basis of race either. And it doesn't matter if the defendant shares the race of a juror being excluded or not. Racially motivated peremptory strikes are illegal, period, doesn't matter who's doing it. So are we going to see Batson or reverse Batson challenges in this case? Do the Manhattan prosecutors or do Donald Trump's attorneys have any interest in getting people of a particular race excluded from the jury? Well, to answer that question, you really have to answer this question. What kind of a jury do the parties really want? Well, that's easy, right? Donald Trump wants 12 white dudes wearing MAGA hats and QAnon t-shirts, while the prosecutors want the United Colors of Benetton with NPR tote bags and lapel pins. Easy. I mean, yes, but no. The reality is that the kind of jury you're looking for really has to reflect your trial strategy. In many cases, prosecutors look for exactly one kind of juror: alive, awake, and sane. That's because their trial strategy is, this guy's really guilty, look at this mountain of compelling evidence. After all, prosecutors get to choose the cases they bring to trial. They work with law enforcement to find and develop the evidence and often wait to bring charges until they're satisfied that they can prove the case beyond a reasonable doubt to any jury. And prosecutors, usually win at trial. It's to be expected. Honestly, I wouldn't be surprised if that's more or less the position of the Manhattan prosecutors. Confidence that they have the goods to prove that Trump falsified business records to cover up the hush money payment, which amounted to an illegal campaign contribution. So their goal is just to get rid of spoiler jurors. The die-hard Trump supporters, sure, but also the conspiracy theorists and the compulsive contrarian. What about Trump's trial strategy? If I had to guess, beyond the Hail Mary full acquittal, Trump's attorneys have two realistic and complementary strategies. First, try to get a juror who will vote to acquit regardless of the evidence. And second, try to get a jury that will only convict him of the lesser misdemeanor offenses. Let me explain. Trying to get a juror who will vote to acquit regardless of the evidence is the hung jury strategy. The upside, of course, is no conviction. But the downside is that a hung jury just restarts the trial. This can be a particularly effective strategy when the state made an unattractive plea offer before trial, but then maybe feels compelled to make a sweeter offer after the hung jury. After all, prosecutors aren't big fans of doing a time and resource-intensive trial all over again. And if there's a second hung jury, chances start getting pretty good that the prosecutor starts thinking about dismissing the case entirely. The hung jury trial strategy relies on the spoiler juror. Just like the state will be trying to avoid those jurors, the defense will seek them out. Again, diehard Trump supporters, sure, but a savvy defense attorney will look for the compulsive contrarian, the overthinker, the person who needs to be the smartest person in every room they walk into, regardless of whether that's true or not. In the absence of a true spoiler juror, the other trial strategy is going for the lesser misdemeanor offenses. The crime of falsifying business records, by itself, is a misdemeanor under New York law. It only becomes a felony when there is intent to commit another crime or to aid or conceal the commission thereof. It could be an effective argument for the defense to say, hey look, Mr. Trump falsified these records of payments to Michael Cohen, but he did it because he was embarrassed about his infidelity from years ago and he wanted to keep it from his wife. It didn't have anything to do with the presidential campaign. This kind of trial strategy has the benefit of looking reasonable. You're accepting some responsibility for some alleged criminal conduct, but arguing that the state is overreaching on this other alleged conduct. In a way, this trial strategy works by pandering to the egos of some jurors. You're smart, you see how this stuff over there was proved beyond a reasonable doubt, and you're also smart enough to see how this other stuff over there was not proved. For this trial strategy, Trump's attorneys would probably want people who, frankly, aren't that smart, but who think they're pretty smart. Like, not quite Zoolander level, but, you know.
What is this? A center for ants?
In other words, confident mediocrities. People who would say, look, I'm not saying the moon is made of cheese. I'm just saying I don't buy the narrative that it's not. I've heard some things that make me think that there's more to the story.
I have not read it, but we should read the transcript. We should.
Getting a jury to convict of just misdemeanors would probably result in very few negative political consequences and possibly some positive political consequences. It ends up being a paperwork crime. And it could fuel the narrative that prosecutors are overreaching to harm Trump's election chances, which could, in fact, help Trump's election chances. But really, who knows? No one can predict what will happen over the next few weeks, except that Justice Merchan will do everything in his power to get a jury duly impaneled. Once that happens, it's off to the races. The prosecutors will put on their case, and Trump's attorneys will try to poke holes in it. The first ever criminal trial of a former president. May we live in interesting times.
Thanks, Spencer. Yeah, the first week of jury selection has gone about exactly as you would expect. On day one of jury selection, things heated up when the lawyers went through the social media posts of the prospective jurors. Trump's lawyers objected to the potential juror in seat 1A because of Facebook posts showing people celebrating in the streets of New York in 2020. Todd Blanche said that people were celebrating Trump's defeat, and the juror said that she reposted the video because it reminded her of the 7 p.m. celebration of frontline workers during COVID. Blanche wanted her dismissed for cause, but the judge said there was no evidence of bias. And this exchange left Trump muttering in disgust, which prompted Judge Merchan to warn Trump to be quiet. Blanche then challenged the juror in seat number 2. At issue was a Facebook post that read, quote, good news, Trump lost his court battle and his unlawful travel ban. Get him out and lock him up. Justice Merchan said that if the post had ended at the travel ban, he would have remained on the jury. However, since the juror mentioned a desire to lock him up, he dismissed that juror for cause. And as jury selection went on, Trump got to listen in while lawyers read mean Facebook posts about him. At one point, a juror was challenged because their spouse posted a joke about Trump and Obama, orange is the new black, but Judge Merchan said that he wouldn't dismiss someone because of a mild Facebook post from 8 years ago. And as Spencer previously explained, jurors can't lie on their jury questionnaire, and on day 2 of jury selection, we got an example of this. The prosecution moved to dismiss juror number 4, who had told the court that he had never faced criminal charges or investigation, but the prosecution found an article from the 1990s about a person with the same name as the juror being arrested in Westchester for tearing down political advertisements. That juror's wife had also been accused or involved in a corruption inquiry in the 1990s before entering into a deferred prosecution agreement with the Manhattan DA's office. And apparently the juror had ripped down posters on the political right. So that juror was dismissed. Juror number 2 was dismissed after Fox News reporter Jesse Waters speculated about her identity and her fitness to be on the Trump jury. The media reported that she was an oncology nurse at Sloan Kettering Hospital, and the juror reportedly said that no one was above the law, and the juror's friends and family quickly realized that she was on the jury. She told Judge Merchan that she was concerned about her identity already being public knowledge and that she didn't want to be on the jury because of the potential threats. And so the judge dismissed her from the jury as well. The judge then ordered the media not to print details about the juror's employment or other identifying characteristics. For example, there was apparently no need for anyone to mention that one of the jurors had an Irish accent. And the press was ordered not to report on answers to questions 3A and 3D, but you can expect the press to probably challenge this order. But by the end of day 2, they had 12 jurors, and on day 3, they picked 6 alternate jurors. Politico has the rundown of the basic characteristics of each person, and they include a corporate lawyer, a software engineer, an immigrant from Lebanon, an investment banker, a speech therapist, and a man from Ireland who will be the jury foreperson. And despite the fact that Donald Trump will be on trial for multiple felonies, he just couldn't stay awake. He reportedly fell asleep multiple times throughout the voir dire process. Obviously, he really could have used some great coffee, which he could have gotten with today's sponsor, Trade Coffee. Trade's great because not only do they have a huge selection of your favorite coffees, but they have a matching process that lets you discover fresh coffee from across the globe based on your taste preferences. To get great coffee every week or gift a coffee subscription to a friend or loved one, all you have to do is choose how often you want to receive your beans, and then you can personalize the rest. Now, I have very specific tastes in coffee. I basically want something that tastes like hot chocolate and pairs well with milk, and Trade was able to find me the perfect bean. And you claim you wanted tea-like natural processed light roast, but you really want a dark roast and taste like chocolate that you can load up with half and half. But either way, Trade has you covered. And now that spring is here, it's the perfect time to drink ice cold cold brew, which Trade also has a huge selection of. And if you already know what you like, they probably already have your preferred roaster in stock at a great price. You can choose whole beans or your preferred grind, and your coffee is roasted to order, so it's coming to you really fresh, way fresher than some supermarket coffee that's been sitting on the shelf for weeks. And for a limited time, Trade is offering $15 off on select plans, and you get your first bag of coffee free. All you have to do is click on the link in the description or the one that's on screen right now. It's a great opportunity to spice up your morning routine and try some delicious coffee. So get your first bag free with $15 off by clicking on the link below. After that, click on this link over here for more Legal Eagle, or I'll see you in court.